So we were going to talk about the latest filing within Stuttering John's lawsuit, which of
Yes.
course came from defense counsel Danny Savalos. So we're pulling up that letter right now. Thank you so much. So this is a letter that Danny, who is defense counsel for Karl and Shuli, addressed to Judge Vincent D'Onofrio. Damning letter, if you ask me. But the intent of this letter and what Danny is asking the court to do in this letter is he is saying that, hey, judge, I believe that you need to know a couple of things about this lawsuit. The first thing that I think that you need to know is that there might be an issue with the attorneys that are representing John. The second thing that I think that you need to know is that there might be an issue with some of the witness affidavits that were submitted by John's team, by the plaintiff's side. And the third thing is that I would like to request for an in-person status conference in order for us to be able to discuss these issues. And I would like us to discuss these issues before we actually have a ruling on the pending motions and cross motions that all exist under your honor's nose. Would you say that that's a relatively good summary of this here letter?
Yes, it is. Yeah, great summary. And I still feel like this is so weird because we definitely do not do this in North Carolina, which is where I practice, because it can get totally out of hand, as we saw in this court file, where the poor judges got inundated with letters and maybe emails, a bunch of correspondence back and forth with these attorneys. So the judges here where I practice, they don't have time for all this back and forth, nonstop flurry of communications. You can't just contact the judge. You have to file like a response or file a motion, then schedule it. So it's very formal. So it just seems weird that somehow in New York they let people do this with the poor judge. I mean, I don't know how the judges can handle this. Yeah.
This case in particular is even crazier because, as both you and I know, and probably as a lot of people who are watching know, there are just thousands of pages of documents in this case. This is filing number, oh, what is it? This is filing number 82 in this court
Wow.
case. And there have not
Crazy.
been, there's only been one decision, and there have been 82 filings, each one. Some of them are 50 pages long.
Yeah.
So, we have huge amounts of paperwork. I can't imagine some judges in New York State still like to have a physical printout of everything so that they can go through it. I can't imagine having, some law clerk come and set down this huge stack of papers on this judge's desk. I imagine that they would be very frustrated by that. So this letter, although it definitely is not common in many jurisdictions, I think that in New York we see a little bit more of this because so many of the judges in New York State do get kind of inundated. And so a letter like this can kind of indicate to the judge, hey, listen, we kind of want you to maybe put a little stay on the action so that we can look at these issues first. Would I say that this is common? Absolutely not. I would say that nothing in this lawsuit has been common. And this in particular, and I know that one of the aspects of this filing that you are the most interested in, it comes on the second page, where they are talking about the issues of John's attorneys potentially having quit, and in particular, John's attorney, Tabor Benedict, potentially having filed some arbitration against John himself.
Yeah. And I kind of lean towards thinking that's totally fake. Anyone can just type up a Word document and say, hey, I'm putting it on the internet. Look, breaking news is. How would anyone even get that? Because arbitration is totally separate from the court system. And
Yes.
That's why a lot of people, especially corporations, they prefer arbitration because it's not public record.
Yes,
so
absolutely.
Unless John somehow received it and then he gave it to someone who then posted it on Reddit, which seems pretty strange.
I mean, that is plausible. I will be honest. I do know that people talk, and I know that there's always a behind the scenes conversations, but I agree with you that this does not seem particularly credible to me. I think that this arbitration notice is likely not a real thing. The only thing that makes me really think that it's real, and I will say actually before I discuss why I think that it has a small chance of being real, I will say that Danny Savalos, who again penned this letter and who is citing this Reddit post that has this screenshot that we're looking at here. Danny does specifically say, I do not have any way of verifying this document, this screenshot. And he says, and quote, there is no shortage of pranksters in this online universe. So even Danny is admitting this might not be real, Judge. We don't know if this is real. Now, to me, the only credibility to this being real is that Danny, before filing this letter with the court, he sent a copy of this drafted letter to John's two attorneys, Tabor Benedict and Bennet Suesser. And if I were Tabor Benedict, or if I were Bennet Suesser, and I saw these allegations in a drafted letter, I would be all over the place going, that's not true. Don't tell the judge something like that. Don't even insinuate something to the judge like that that isn't true and accurate and real. And so the fact that they were silent on that, to me, says maybe it is real.
Yeah. It just seems unprofessional for these attorneys of record to completely ignore Danny Savalos. I mean, he's trying to push the case along, whereas supposedly John's attorneys have pretty much shut down and won't even respond. And that's weird, because if you're not representing the client, then you should properly withdraw. You can't just quit.
Absolutely. You have to properly withdraw. You are not allowed to just abandon a lawsuit. In fact, that's one of the reasons that people get law degrees, is so that they are doing things by the legal procedures, so that they are doing things correctly, because your attorney is supposed to literally and figuratively represent you. This is somebody who is supposed to be your advocate. They are supposed to be helping you. And if your attorney is failing to help you, either by having a failure to communicate or by not practicing law in the best way that they are able to, then that is a major problem. And when I talked about this previously, I insinuated that, or I suggested, not even insinuated, I said, to me, this seems like it might be a malpractice if there has been this breakdown of communication. What I don't know is, I don't know if the breakdown in communication has been coming from John's attorneys, from Tabor and Bennet, or if the breakdown in communication has been coming from John. If John's attorneys are in fact passing this information along to John, not a malpractice to me. It doesn't seem like they're doing anything wrong. They're trying to get John to respond to things. But if they're not even responding to anything at all, and if John isn't aware of the goings on in his own lawsuit, and that's due to his attorneys not telling him things, that seems very serious to me. Would you agree that that's something that potentially could be a malpractice, or am I way off base on that?
I'm accuse his attorneys of malpractice, because we have no idea what's going on behind the scenes. Because
no idea.
You know, there've been plenty of times when I was involved in some sort of litigation case, and I started having conflicts with my clients, but I still can't tell the opposing side what's going on. Like the client's being a total jackass, or turns out the client turned on me, or, you know, the client's not paying my bill. He lied to me. You know, I mean, you still have to keep that confidentiality. But if it turns out that for some reason they can't represent him, or they feel like he's not cooperating, or he's not paying them in accordance with whatever the fee agreement said, then the proper thing to do, at least where I've practiced, is you have to file a formal motion to withdraw, then schedule it for a hearing, unless your client consents to it.
Yes.
Yeah.
That is a very, very similar process as to New York State, at least my understanding of the process in New York State. So I definitely, the fact that we have not seen either of these attorneys withdraw means that they are still technically representing John, even if there
Yeah.
has been a breakdown in communication. And it's peculiar to me that if there was a breakdown in communication, that they wouldn't just file that in order to get out of it. I wouldn't want to, if there's a reason that I don't want to represent somebody, then boy, oh boy, do I want my name off of that immediately. I don't want the responsibility anymore. Get me out of here.
Yeah. Yeah. Oh, can I show something from that
Sure.
arbitration association?
Yeah.
Okay.
Yes.
Because sometimes people think that arbitration is such a great thing because it takes it out of the court system. It's supposed to be faster and confidential, but usually arbitration is usually more of a negative, especially for the poor party. So this is also why I think that it's probably unlikely that the attorney really took it to the arbitration association,
Yeah.
because it actually is kind of expensive for most people to arbitrate because it's not free. So this is
Really?
from the AAA, or they call it ADR.org, from their website. And for a commercial case, you still have to pay an initial filing fee of, let's say in this case, $14.50 plus a final fee of $1,150. And you also have to pay the arbitrator. Most of them are people who used to work for big law firms. So you could get some certified arbitrator who is going to charge you $1,000 an hour. That's not just for the actual proceeding, but also for the time spent reading, reviewing documents, drafting the decision. So it could just be totally expensive to do this.
So I'm very unfamiliar with arbitration. Are those filing fees and those associated fees that you just described, are those things that the plaintiff would need to actually pay for? So in
Yeah.
this case, it would be Tabor would be paying
Yeah.
these fees.
Yeah. So
So
I've never, yeah. I mean, so why would an attorney say, if we have some sort of dispute, we're going to turn it over to arbitration with a certified arbitrator? Because, if this is a big if he only owes $7,800, then you could wind up spending just as much on the fees to
yeah,
do it. So, plus, didn't John say repeatedly that he doesn't pay lawyers? It's on a contingency fee
contingency,
basis.
contingency, contingency.
Yeah.
He sure
So,
has.
so I don't know what the truth is, but arbitration isn't free. So let me just
Yeah.
take that. I just want to get that out there because most people gloss over these things in contracts because they think it's a good thing, but it could turn out to be a total negative.
That's a really great point. And so let me see again, I'm going to kind of make a guess here. And you can correct me if I'm wrong, because again, I know so very little about arbitration. So let's say that Tabor did actually file this arbitration hearing against John for $7,800. And let's say that it ends up being a wash. He ends up, breaking out exactly even. The reason to do that in a lawsuit that is public might be because you want the vindication of, sometimes you end up losing money in a lawsuit, but you want to do that because you want the person to pay for what they've done. In a lawsuit that is filed with the civil or Supreme Courts, everybody gets to see that they are paying for something that they've done. In these arbitration hearings, there would be no vindication of the fact that John was in fact in the wrong. So it would be even more peculiar. And again, this is I'm kind of spitfiring and making conjecture here. I would think that if it would be possible for Tabor to be losing money, that he would want to do that in a way where John was penalized both financially and publicly. I don't know, maybe.
Yeah, because you want
That's a
it
guess.
on the record that, hey, this this person, if it's
Yes.
true, screwed me over, his credit should be harmed. I want a judgment so everyone can see it.
Yeah.
Yeah. And also, this is a total side note, but let's say he decided to sue John in small claims court because,
Yes.
most small claims court you can sue for up to 10K. Um, it's difficult though because the client is totally far away. At least where I practice, you can't sue the person in small claims court unless they live in the same county where you're suing
Oh.
them in small claims court. So it becomes more of a hassle. And this is why, a lot of attorneys might be like, I'm not representing this person who doesn't live anywhere near me, because if they screw me over, how am I supposed to get paid? It's a real hassle to have to sue someone.
That
Yeah.
is very interesting. And of course, it ties into the Stuttering John lawsuit against Karl and Shuli, because there has been this change of venue
Yeah.
from New York County, Manhattan, where it was originally venued, to Rochester, New York, which is about 5.5 hours away from New York City, in Monroe County. And so that has been a big change in this lawsuit with Stuttering John. And that, of course, is a part of the alleged communication breakdown between John and his attorneys, which is, are they going to come to Rochester if there are hearings set? If a status conference is set, as Danny Savalos requests in this letter, will either of John's attorneys actually show up in Rochester in order to represent him?
Yeah. The other attorney, is it Suesser? Where
Yes.
is he based out of?
He's also based out of New York City.
Oh, okay. So it's going to be a huge expense if they have to go there for multiple hearings and
It
depositions.
it
Yeah.
is. And if they're not getting paid, that money might be coming out of their pockets.
Yeah. I
I wouldn't
mean,
do it.
yeah, I wouldn't do it either. I'd be like, heck no, I'm not driving 5.5 to 6 hours. And who's going to pay for the hotel? Who's paying for the court reporter's fees? It's very time consuming.
Very time
Yeah.
consuming, very, very time
Mhm.
consuming. And especially if there is concerns about payment, or if this is all on contingency, you probably go to sleep at night thinking, boy, I could be making so much more money doing something else.
Yeah, exactly. Well, also, this is if you feel like after a while the client's credibility isn't that great, then it's kind of like, do I want to take that risk? It's probably not worth it. You have to weigh the costs and benefits of spending so much time working on someone's case and then possibly getting zero.
You do. And there has definitely been speculation that the reason that Bennet Suesser took on this case is because he's a stand-up comedian. So he wanted the closeness to Stuttering John Melendez for the infamy, for the fame. If that is the case, and he took on this case for free, if that is the case, again, big if, um, maybe he has realized since taking the case on that Stuttering John isn't quite as liked as he was back when he was on the Howard Stern show. And perhaps if that realization is occurring, that could be a reason to kind of take a step backward and feel a little bit more uncomfortable with representation.
Mhm.